Hello, I'm Simon Wolfe, Managing Director of Marlowe Strategy. I'm organising and hosting a new interview series exploring how companies and governments navigate new environmental, social and governance challenges in complex operating environments. As we navigate the green transition, we must acknowledge that the minerals necessary for this transition are often found and processed in low governance jurisdictions, and in some cases, those which are mired in conflict. This series explores how companies and governments should approach this reality, the standards to abide by, and learning lessons from the past. To do this, we are speaking to international experts to unpick the challenges and highlight solutions. Today, I have the tremendous pleasure of welcoming Peter Leon, who's the partner and Africa co-chair at Herbert Smith Freehills. During the last decade, international who's who of mining lawyers, Best Lawyer, Legal 500, Chambers of Partners, and other peer-reviewed global legal directories have consistently identified him as one of the world's preeminent mining lawyers, and in 2021 named him as one of the top mining lawyers in the world. Peter excels in helping resolve contentious issues arising from mining projects and related developments in Africa. His areas of expertise include crisis management, resource nationalism, mineral and petroleum regulation in developing countries, including international best practice, international investment law, and investment protection. Peter Leon, it's a great pleasure. Thank you and welcome.
Thank you very much, Simon. Good to be with you.
I'd like to get straight into it, Peter, with a general question. How are legal norms for international businesses changing in terms of the ESG agenda?
Well, they're changing enormously. I mean, we've got this green energy transition going on in Europe that's putting significant pressure on, and obviously I work principally in Africa, although I've done quite a lot of work in Saudi Arabia in the last year, but putting tremendous pressure on mineral producers in Africa to comply with ESG standards. And it's not just, as you know, Simon, an African issue, because one of the world's leading mining companies, Rio Tinto, has experienced significant blowback on the Juukan Gorge debacle in Western Australia in the last year, which led to the loss of its chief executive and some of its senior management. So, I mean, ESG issues, I know they've come to the fore in the last year. I don't think they're simply a passing fad. I think there is huge issue around environmental, social, and governance issues for the whole extractive sector, not simply the mining sector, which I work principally in, but obviously the oil and gas sector, given the statements by the International Energy Agency around decarbonization and the rest of it. And then you've got the Shell judgment recently in The Hague, where the district courts basically told Shell to reduce its carbon emissions globally by 45% by 2030. So, I mean, it's coming at you every which way. I think initially there was a view this is being driven by activists, investors in the US, millennials and the rest of it. But I think it's much more than that, because you've got all these issues coalescing around climate change, around the treatment of mine communities, around Indigenous people, on the social side, around governance, human rights, and the rest of it. So I think it's a whole new ball game for the extractive sector. And in mining, you've seen this in fossil fuels, where all the majors, most recently Anglo American, have divested their thermal coal assets. And I know that's also created some controversy, but I don't think they had very much option. And the question is it better to divest through a demerger, or do you divest through selling the coal assets to a company which may not be very well known and may well not manage those assets as well as the major did previously? So there are issues around that. I just think we're into a completely new area for the extractive sector, which is going to put very significant pressures on boards of mining and oil and gas companies going forward in the next 10, 15 years.
So in that case, how do companies assess political and ESG risks, especially when working in these challenging markets and environments?
Well, I mean, the one thing is to do very, very careful due diligence around those risks. I think, I mean, certainly based on my experience in work in Africa, the risks are, I mean, there's certainly environmental risks, leave that to one side for a moment. But the social risks are what causes the issues, in my experience, for mining companies. I mean, if you look, for example, at the issues that Acacia faced in Tanzania, where the government used a tax audit of hitting the company with a $190 billion tax bill, which I was involved with, to go after the company and basically make it unviable for them to continue operating in the country, or Konkola Copper Mines, Vedanta-owned mine in Zambia, where the government used the state mining company to put Konkola Copper Mines into provisional liquidation, where it stayed for the last 2 years. In both cases, I think the social issues on the ground, combined with the feeling in Tanzania that the government wasn't getting a fair share of resource rents because of the tax holiday that Acacia had when the original investment was made in the country in the 1990s, where Tanzania was opening up its mining sector in the wake of reforms which were advocated by the World Bank. So yeah, I think a lot of this has to do with fairness and the stability of the relationship between the government and the investor. But if the government feels that it's not getting a fair share of resource rents, it's likely to act against the company. So I think the days, Simon, where mining companies could say, as they did, I did work in Ghana some years ago, well, they've got a 30-year stabilization arrangement with the government for the life of the mining license. And if the government breaches those stabilization provisions by trying to amend the mineral development agreement, they'll take them to international arbitration. I think those days are over.
I'm really interested in unpicking those two examples you raised of Acacia and Tanzania and Vedanta and Zambia. I think they're very much representative of what can go wrong when the host government takes a turn towards resource nationalism and changes the rules of the game, as you've just highlighted. But what can a company do to mitigate those risks before they happen? And how should it respond when faced with a recalcitrant host government or an unstable political security situation?
Well, I think it's, the key thing is to anticipate those risks arising and then managing them as they happen. I think the key thing in my experience, I mean, obviously your ultimate recourse as an investor, assuming you have recourse under the investment agreement or under a bilateral investment treaty or the shareholders agreement, in some cases where you have the government as a shareholder, if you have recourse to international arbitration, that of course is your ultimate weapon, because that puts a lot of pressure on the host state to resolve the issue. But I really don't think it is the solution, because at the end of the day, you've got to have a relationship with the host government which is going to be sustainable in the long term. And if you take the government to international arbitration, what sort of relationship are you left with when you landed with a huge damages claim, which the government might not pay? So, I mean, it might be a very short-term win and a long-term defeat. So I think I'm a great believer in Churchill's adage, Simon, of jaw and not war, although he practiced the latter in relation to Hitler. But I mean, I think it's absolutely key to have a dialogue with the government. And the government, often in these situations, I've found the government, I mean, take the example in which we've highlighted, Tanzania and Zambia. Basically, Magufuli, the former president, said to Acacia, "We want you out of the country, not prepared to talk to you." Lungu, the president of Zambia, and there's an election on the 12th of August, so it's around the corner, said to Vedanta and to Glencore, "You're not welcome in the country anymore. We don't want to have you." So basically saying the same thing. So I think in that situation where the president is refusing to talk to the company, you need to engage, you need to do two things. One is to try and find someone the president is or the government's prepared to talk to, who is an interlocutor, an intermediary, who is respected by the government and who's not in the pocket of the mining company. But the second thing is to bring in, and I've done this in the past, to bring in some of the international agencies which have influence over that government, such as the World Bank and the International Monetary Fund, because very often in those countries, they will have either be on a fund program or the World Bank will be providing advice to the government. If neither of those factors are present, then it's much more difficult. I accept that. But there will always be, I think, players in the sector, if they're not the International Monetary Fund and the World Bank. The African Development Bank is another player in Africa, which certainly has some influence. And the governments of foreign investors who are involved in the country can also be brought into play in terms of their embassies and their foreign ministries. So I mean, there's no cookie cutter approach to this. My experience is you need to think out the box, you need to be very imaginative, and you need to use all the leverage you have. But it's not a straightforward situation at all.
I think it's fascinating you talking about bringing in, say, head office governments to help put pressure on a host country in terms of acting appropriately with respect to the investment. But what happens when that company faces pressure in its home jurisdiction with respect to its conduct in the host country? And I go back to Acacia, and as you'll recall, they faced accusations from NGOs that Tanzanian security services engaged in killings and violence in and around the mine. How should a company deal with allegations if they're not directly responsible, but are nevertheless accused of complicity?
Well, then they need to, frankly, in that sort of situation, engage in a public relations campaign to address those issues. And I mean, often a way around that is for the company itself to create an investigation into those human rights abuses and publish the outcome of that investigation, even if it's unfavorable to the company. Why do I say that? Because I mean, it's not the only country in which that's happened. I think that's happened in Sudan in recent times as well with Lundin. But I think it's very important for the company to have credibility and to own up to mistakes it might have made in the past. I mean, the issues that Acacia faced in Tanzania on human rights issues around North Mara mine were historical, and frankly, they were not well managed by the company's previous management. But by the time this issue blew up, it was years later. So I think, you need to have credibility. You need to own up to your mistakes. And I think appointing an independent investigation by a respected person, whether that person is a lawyer or a human rights advocate or whatever, who has credibility, it can be one way of addressing that situation. Because very often, in my experience, those issues are historical and they might have happened 10, 15 years ago. But I mean, the other thing, important point I do want to make is I think it's very important for companies involved in the extractive sector to sign up and apply the voluntary principles on security and human rights, which were negotiated some years ago, involving not just the mining sector, but the oil and gas industry. And they're a set of voluntary principles and they're not mandatory. But once the company signs up to them and they're policed by governments who were involved in negotiating those principles, Switzerland in the past, Britain and others, the company is subject to evaluation under those principles. And one of the things the voluntary principles are very strong about is the use of private security companies in trying to prevent those sorts of abuses.
Do you think that the extractive industry is now more reluctant to move into or remain in certain territories for fear of investor, political, legal repercussions?
I think that was the case in the past. I mean, to my mind, what's really interesting, what's happened in the last couple of months is, and I know that Robert Friedland of Ivanhoe is making a big thing about this is that countries which were always regarded as extremely hospitable to foreign investors for mining, I'm thinking now of copper with the green energy transition, Chile and Peru, were exemplars. I mean, Chile was always held out, rightly so, I have to say, as having the best mining code in the developing world. And Chile's no longer really a developing country, but is now a member of the OECD. Obviously, it's the biggest copper producer in the world, followed only by Peru, which is number two. And major mining companies have invested heavily in both those countries. But as you know, Simon, both those countries are undergoing a very significant transition. I mean, in Chile, there's, I think, a high probability that the Pinochet era constitution is going to be shredded in terms of who's been elected to the Constitutional Assembly. And in Peru, you've had the election, looks like the election of Pedro Castillo, who's a hardline socialist, over Fujimori in the last week or so. And so, I mean, and he likewise has said that the constitution in Peru is too neoliberal. The mining companies need to face a new fiscal regime and the rest of it. So why I'm saying that is that those countries in Latin America, Peru and Chile, have always been regarded as safe investment destinations compared with, say, the DRC. So the point that Robert Friedland's making, obviously talking to his own book in a way, about Kamoa-Kakula, which is his new mine in the DRC, which is jointly owned by the DRC government, Ivanhoe and Zane, the Chinese miner, is that mine in Katanga province in the south of the DRC represents a new era for copper mining. And the other argument he makes is that if you compare the DRC with, say, Chile, the DRC for copper mining purposes is much less carbon intensive because it relies on hydropower, which is not the case in Chile. Now, obviously, he's talking to his book, but what I am saying to you is that I think there may be a shift in investor perceptions around Africa in relation to Latin America around mining. So I don't think it's sort of binary choice anymore. And you in Western Australia, to go back to the example with Rio, where you have one of the world's best mining companies in certainly what's regarded as the world's best mining jurisdiction, which is Western Australia. Even there, a major mining company got caught up, in a significant heritage issue, which had significant consequences for it. So I think the navigating these issues is extremely difficult and complex.
Well, so one way that you certainly help with that is your involvement in helping governments create and reform mining codes. How do mining codes help companies prepare? Do they have the right governance in place to ensure that they comply? In your experience, how does that work?
Yeah, mining codes are extremely important because there certainly are examples in the civil law jurisdictions, coming back to Africa, and obviously Latin America is another example, where the mining code is much less important and you get your rights under a mining convention, which has to be approved, normally, hopefully, by Parliament. So there's scrutiny and transparency around it. But leaving that aside, I think it's generally much better to have all the rights written into a mining code, so everyone knows what's in the code, what they need to comply with. But the code itself, certainly based on my experience in South Africa, can sometimes be the problem. So if you have a lot of backdoor discretion in the code, in South Africa, for example, there's a lot of backdoor discretion around Black economic empowerment because the code, the Mineral and Petroleum Resources Development Act, needs to be read with the Mining Charter, which has gone through 3 iterations, where the Black empowerment obligations on mining companies have become increasingly intrusive. But the problem is those requirements are not in the code. You need to read them with the Mining Charter, and you can't get a mining right in South Africa until you comply with the mining charter. And as I say, the mining charter is complex and become increasingly difficult to interpret. So you've got that issue, avoiding backdoor discretion. The second thing I would say is it's key to have objectively determined rights in the code, so you don't have subjective discretion. That if you meet the requirements for a license, you will get that license, and the regulator's ability to give you that license is constrained because the requirements are very clearly set out in the law. The third thing I would say is the importance of having technically competent people to administer the mining code. So, for example, in South Africa, frankly, I don't think we do. There's a now backlog with the Department of Mineral Resources of 5,500 mining rights and prospecting rights, which the minister disclosed to Parliament recently, which is untenable. Whereas in Ghana, because they realized that was a problem more than 25 years ago, the Ghanaians established a minerals commission where technically competent people run the licensing system, make recommendations to the minister, the president, around the award of mining rights. I think that's a much better model to use. Funny enough, Tanzania, with all its problems, one of the things Magufuli did do, and I think the experience perhaps been a bit mixed, was to set up a mining commission in 2017 to award the licenses. But so I think, having a technically competent team involved in the licensing process is extremely important. The fourth thing I would say is having an online mining cadastre. What do I mean by that? So in other words, an online mining portal where, in real time, you can see who's applied for what rights, what areas are available for prospecting, what areas are available for mining rights, if you have a prospecting right or an exploration right, however you define it. That's very important, having an online mining cadastre. The World Bank has done a lot of work around that. About 60% of Africa's mining jurisdictions, excluding South Africa, unfortunately, now have proper cadastral systems. And then the final thing I would say, Simon, which is key in my view, is having time limits for the grant of decisions. So, for example, in Botswana, which is always rated as the best mining jurisdiction in Africa, if you're compliant with the mining code, you'll get a mining right within 2 weeks. Obviously, it has to be compliant. You might go through a process with the ministry as to whether or not you have complied with all the requirements. Now, with all that in mind, when I had the great pleasure and privilege of advising the Kingdom of Saudi Arabia with the World Bank on their mining code, their new mining code, in the last year, we certainly said to the Kingdom and the Ministry of Industry and Mineral Resources that all those requirements are absolutely key in the law. So in the mining code in Saudi, you now have a situation where there's A, an online mining cadastre, B, objective criteria for the grant of rights, C, time limits for making of decisions, and D, the government has followed international best practice around sustainability, communities, and the rest of it. And the instruction I got from the ministry is we want to follow international best practice. Western Australia and Ontario, the two states and provinces in Australia and Canada, respectively, which we think follow that. And they got advice from the World Bank, as part of this process. And I think you'll see the outcome of that, because that new law is now in effect. We've just finished drafting the guidelines around the regulations, which will help investors understand what is in the regulations. Because the way things work in the Middle East, Saudi Arabia is not the only country. The law is really just an outline. The detail of the law is always contained in regulations, and the regulations are then followed by guidelines. So it's a sort of 3-tier system. But in Africa, coming back to Africa, the mining codes normally contain most of what is in the law. But frankly, unless you meet all those tests, I think you'll find that the mining code is deficient. And coming back to South Africa, one of the issues here has been the decline in exploration, whereas South African mining companies only spending now responsible for about 1% of global exploration expenditure, compared with, I think the figure was 30% 25 years ago. So it's a pretty drastic decline.
I think one of the key benefits, of course, of crafting a well-written mining code is openness and transparency and certainty for investors to come to a country. But you raised, for example, the Mining Commission in Tanzania in 2017, where they applied a free carry for the government. I think it's 15 or 16%. You'll know better than I do. Mm-hmm. But the manner in which they imposed it, I think, is relevant because it was applied retrospectively, which goes contrary to these certainty principles. I mean, what are your views on that?
Absolutely. And I frankly, Tanzania is an example of how not to do it. I mean, to your point, is a 16% free carry, but if you combine that with some of the regulations they introduced in the local content regime, you could land up with the government effectively having 50% of your operation. The real problem in Tanzania was twofold. One is these new laws, there were 3 of them, were passed in the space of 1 week in Dodoma, the capital of Tanzania. The mining companies were given 24 hours notice, effectively, to comment on the new legislation. And the hearings in Parliament were conducted in 1 day. I mean, and the basis on which the government was able to do that was because the Speaker of Parliament, presumably under instructions from the President, issued a certificate of urgency saying this is a matter of national importance, the legislation should be passed so quickly. I mean, obviously, in that situation, you have no transparency, no proper transparency, and a charade of public participation. The other problem with the Tanzanian legislation is that the other bit of it was the government also passed through Parliament a thing called the Unconscionable Terms Act, which effectively allows Parliament to review any mineral development agreements, your point about retrospectivity, and expunge those provisions in the mineral development agreement which Parliament, the parliamentary committee and Parliament regards unconscionable. And if the mining company doesn't like that, well, I mean, there's not much they could do about it. I suppose they could have recourse to arbitration. But of course, the other thing the government's done is compelled mining companies to have any arbitration against the government in Tanzania and banned recourse to international arbitration, which is another issue. And I think that's also because the Tanzanian government in the past has been subject to a number of adverse international arbitration awards over the years. I have to say, in fairness to Tanzania, since the passing of President John Magufuli in March, President Samila Hassan has certainly been making the right noises around the mining and particularly the oil and gas industry. And in fact, very recently, she appointed a new team to try and get the Tanzanian gas blocks, which are adjacent to those in Mozambique, off the ground. Because as you know, Exxon, Shell and Equinor have all basically put their operations in Tanzania on hold, owing to all the uncertainty in the upstream petroleum legislation.
Well, in the oil and gas space, I really want to come back to the decision, the recent decision of the Dutch courts forcing Shell to reduce its carbon emissions by 2030. And firstly, what does that mean for the oil and gas sector? But also, what does that mean for the importance of encouraging investors to go to countries who, in a lot of cases, forms a large part of their GDP? How do we have a sensible arrangement between investment and working with these countries?
Frankly, I think it's going to be a huge issue for Africa. I don't know what Shell are going to do about that judgment. I assume they're going to appeal it Simon, because it's just a judgment of the district court. But as I understand the judgment, it affects all Shell's operations, not simply in the Netherlands, but globally. And as you know, they are a major investor in Nigeria and have been in Nigeria since the 1950s. And in fact, in the last day or so, Shell have announced that they're basically terminating their onshore activities in Nigeria, in Ogoni land, which is the Nigerian Delta, which could have a huge impact on Nigeria. I think this, for African or for developing countries, which are single commodity countries, this is a game changer. So, I mean, this is going to affect, as I see it, Nigeria very significantly, Gabon, Equatorial Guinea, the Republic of the Congo, in other words, Congo Brazzaville, and Angola. I mean, Angola, perhaps slightly to a lesser extent, because at least it has a mining industry and it has tried to diversify the economy away from oil. Also, because it came pretty late to the hydrocarbons game in Africa. But I mean, the other countries. I mean, Equatorial Guinea is a very similar situation to Nigeria, in addition to being an autocracy. I think it's very problematic for African hydrocarbon producers. As I say, I mean, one doesn't know what's going to happen to the district court judgment in the Netherlands, but I can't imagine Shell are very happy about it. But I mean, what is this going to do for the economies of African countries, which are single commodity producers dependent on hydrocarbons, where they don't really have any other significant parts of the economy other than sort of subsistence agriculture? I think it's a real issue.
Chris. So I'm really fascinated by this because I really wonder how we move the conversation to a reasonable point where we accept, of course, that we're all moving in the direction of the green transition. But we have to, of course, take account of those single commodity countries, as you say, who will suffer pretty serious economic damage. How do we have a reasonable conversation so it's not a binary outcome, for example, that the Shell decision might give rise to?
Well, I think that there has to be I think what's going to have to happen with these countries, and obviously it's all in the run up to Glasgow in November, and everything else. And the International Energy Agency's decision on decarbonization. I think there has to be a transition. I mean, you have to give these countries an opportunity to move their economies away from a single commodity dependence. Otherwise, they're going to be in very serious trouble, because if you look at all these countries, those commodities, in this case hydrocarbons, are the major reason that they're for their balance of payments, for their exports, for their foreign currency receipts. I mean, you take all that away, what are they left with? I think, frankly, I think the developed world, the G7, led by the UK in relation to Glasgow, need to be very cognizant of these issues and think around solutions around them, which I don't think, frankly, has happened, because there's so much focus at the moment on the E in ESG and not on the S in relation to hydrocarbons. You think about from a country perspective.
I think that's an excellent point. I'd like to just finish, Peter, on a general question. Over the course of your career, what would you say are the main changes that you've seen with respect to international businesses operating in Africa?
Look, that's a very, very good question, Simon. I think the main changes I've seen, and unfortunately I was fortunate enough to be part of this journey when the democracy came to South Africa, and I was advising some of the major mining companies here on the transition to the new mining code in 2002, 2004, and the mining charter which followed in its wake. When I started doing that, the Washington Consensus, which obviously came about in the wake of the fall of the Berlin Wall in November 1989, and the collapse of the Soviet Union in 1991, when I happened to be in Prague when all that blew up, which is a very interesting time to be there. But is the move away from the Washington Consensus, which drove most of the mineral law reform in Africa. For example, if you come back to Tanzania, even Zambia, the mining codes that were enacted in the 1990s very much followed the Washington Consensus. And what the Washington Consensus involved? It meant getting the government out of business. It meant liberalizing the economy, floating the exchange rate, moving away from, abolishing exchange controls, opening up the economy to the private sector, moving the direction of a market economy. I mean, all good steps, but the problem was that a lot of these countries didn't necessarily see the benefit of it, because in many cases, Tanzania and Zambia again being examples of it, the fiscal regime, because the government was so desperate to get investment into the country, they either gave the mining companies extensive tax holidays for up to 20 years, or the royalty rates, which was the case of Zambia, were so low as to be minuscule and way out of kilter with international model that the country and the citizenry simply didn't see the benefit of that. So what you have a reaction to that in the noughties, and so in Africa, the African Union, the heads of state in 2009 enacted the African Mining Vision, which in many respects is sensible around trying to get more benefit from mining for the country, but it's also very statist. So while it talks about all these linkages around beneficiation, downstream beneficiation, upstream beneficiation, side stream, and you look at it every way you like, I don't think, well, I can see the sense of the African Mining Vision. I don't see how it involves the private sector. So it's a much more statist model. And then moving on beyond the African Mining Vision, you have the steps that have been taken in which we talked about in this discussion in Tanzania and Zambia, where you really see the recrudescence of resource nationalism on a massive scale. But even if you take countries like the DRC, where the mining code was significantly amended in 2018 by the outgoing Kabila administration to increase the state carry, to increase the royalty rates, to increase corporate income tax, to make life, frankly, much more difficult for mining companies to invest in those countries. Those sorts of developments now are much more common in Africa. So, I think the era of the Washington Consensus is very much over. I think we've seen in the last couple of years in Africa a resurgence of resource nationalism. I hope that will settle down, because obviously what resource nationalism does is make investors very skittish. And I think the Tanzanian government in the post-Magufuli era has now realized it's critical for the country to get mining investment and hydrocarbon oil and gas investment back into the country. And the way to do that is, changing the law to make it more investor friendly, because if you don't, at the end of the day, capital is very unsentimental where it invests. And if you don't have a reasonable investment climate, you simply won't get investment in the country. So those are the changes I've seen.
Peter, this has been an absolutely fascinating conversation, and we really thank you very much for coming on, and we wish you all the best.
You're very welcome, Simon. Great to speak to you.